It is 10 o'clock on Tuesday, August 3rd. We will now call the meeting of the Tennessee Board of Funeral Directors and Embalmers to order. Ms. Bohannon, would you please call the roll?
Fred Berry.
Here.
Anthony Harris.
Here.
Tanya Scale-Haynes. Clark McKinney.
Here.
Scotty Porsche.
Here.
Charles Rahm. Robert Shackelford.
Here.
Mr. President, we have a quorum.
Thank you, Ms. Bohannon. We'll entertain a motion to adopt the agenda that has been presented for the meeting this morning.
So move.
We have a motion by Mr. Harris. Do we have a second? Second by Mr. Berry. Any further discussion? All in favor say aye.
Aye.
Opposed? Motion carries. We will now review the minutes from our June 8th meeting. You have those on your iPads, and they have been emailed to you prior to this meeting. We will entertain a motion to approve the minutes as presented or to amend them as required.
Move they be accepted.
We have a motion by Mr. Berry that the minutes be accepted as presented. Do we have a second?
Second.
Second by Mr. McKinney. Any further discussion? All in favor say aye.
Aye.
Opposed? Motion carries. We welcome Mr. Anthony Glandorf, Chief Counsel of the Regulatory Boards Division, to our meeting this morning. Mr. Glandorf, we appreciate your service to this board, and we invite you to present the legal report at this time.
Good morning. Thank you all. Good to see you all here in person. I think you all should have the legal report in front of you, and I will, as I understand is the norm for the board, I'll read each of these and give you all opportunity to ask questions or discuss as appropriate. With that, I'll generally read the complaint number and then the summary and then my recommendation out there. The first one is 2021-023991. Here, the complainant is a pre-need sales agent who contended that the respondent, who is a funeral director, used his notary public seal and forged his name on documents. The respondent denied the allegations. We attempted to conduct an investigation, and during the investigation, the complainant would not agree to meet with the investigator. When the investigator finally, after some time later, found the complainant at his home, wherein the complainant stated he wished to withdraw the complaint in this matter, and as ancillary to that, stated that he was going to go back to work for the respondent. As such, there's no evidence of any forgery and unauthorized use of a notary sale. I would recommend to close this complaint because the complainant did wish to withdraw it.
Motion by Mr. Berry to accept council's recommendation of closure. Do we have a second?
Second.
Second by Mr. Harris. Any other discussion? All in favor say aye.
Aye.
Opposed? Motion carries.
The second one before you is number 2021-026401. Here, the complainant is a licensed funeral director and embalmer at the respondent's funeral establishment. The complaint is upon the owner who is an unlicensed person who's not licensed by the board as either. The complainant makes allegations about poor working conditions in general, particularly during the COVID period, for lack of proper PPE for embalming. Also, there was allegations of discriminatory statements regarding race and gender, and a lack of apathy, for the exhausting conditions, and also general harassment. And the harassment would have been about lack of work performance. Further, the complainant makes allegations of unlicensed activity on part of the owner, stating that they made telephone calls for arrangements with potential customers. This was done to the knowledge and this would have been done to the knowledge and in the presence of the complainant, who is a licensed funeral director. Given such, the claim of that could not be substantiated. The allegations regarding the workplace conditions are not within the authority of the board. Those are other departments who make those determinations regarding workplace conditions, and should be made to the proper agency without the authority over employee-employer relationships. As such, my recommendation would be to close this complaint.
So one question, so our board inspectors would not be responsible, at least for the claims of the preparation room?
PPE?
Mm-hmm.
I don't see how. During the COVID period?
Well, just ensuring that proper materials were there. I know there were shortages and things like that, but
Would have been masks, gloves, eye protection and whatnot, which would be for workplace conditions. I'm not sure if there was an absolute requirement for what's required to be under the board's rules. I think there was some guidelines from the CDC and from some others as to what could be required, but I'm not sure that there's an absolute board rule as what's required to be worn during embalming.
Regarding the allegation that the unlicensed owner made telephone arrangements with potential customers, that was just a situation where the complainant said yes he did and the respondent said no he didn't, and there's no other
Exactly.
evidence that can be gathered.
There's no other evidence that
No
could
other
be
people to speak with.
gathered for that. It also makes it more difficult also when you could have somebody who's assisting a funeral director in the presence of a funeral director making those arrangements. That's typically allowed when it's in their presence because they're assisting. So it seemed an odd quagmire that they heard and knew what was going on because they were there present. And so is what their statement was. But yes, generally we could not substantiate it from any other third party there. Council.
Motion by Mr. Berry to accept council's recommendation for closure. Do we have a second?
Second.
A second by Mr. McKinney. Any other discussion? All in favor say aye.
Aye.
Opposed? Motion carries.
The next one is number 3 on your report. It's number 2021028661. Here, the complainant is a North Carolina funeral establishment that received the remains of a deceased that was transported by a licensed Tennessee funeral establishment, who is the respondent. The complainant originally alleged that payment was sent with the remains to the respondent, but included the incorrect name of the funeral establishment on the check. It's in North Carolina. However, after the complaint was filed, the complainant states that this matter was resolved by the respondent having received the correct check name in the check. The complainant requested this matter be closed upon review. It appears that this matter was settled amongst those parties. As such, I recommend that this be closed.
Motion to approve.
Motion by Mr. McKinney to accept council's recommendation of closure. Do we have a second?
Second.
A second by Mr. Harris. Any further discussion? All in favor say aye.
Aye.
Opposed? Motion carries.
Thank you. So the next one, number 4, is number 2021031021. It's slightly lengthy, so I'm going to attempt to avoid confusion while I read it here. Here, the complainant alleged that the respondent, who is a funeral director, failed to allow the complainant and relatives of the deceased to view the human remains of the decedent prior to cremation. The issue was regarding the COVID status of the decedent. The complainant alleged the decedent received multiple negative COVID tests from the hospital prior to release to the respondent. However, the respondent refused to follow up on this notion and refused to allow family the viewing. That was the statement of the complainant. The complainant, however, did not provide any documentation of any COVID test result or other documentation showing such. The respondent provided a release documentation from the hospital which states that the decedent died of, quote, communicable disease, and there was a notation that stated, quote, rule out COVID. Nothing further was stated on that. Further, a photo was provided by the respondent, which he alleges is from, apologize for the wording there, for the bag in which the decedent was placed in the hospital, which did indicate, with writing, COVID pending. The complainant states that the doctor treating the decedent indicated several times to the complainant that the decedent was COVID negative and also informed the respondent. The respondent denies this. The respondent stated that and provided CDC guidelines indicated that there was a risk of spreading COVID to others if touching unprepared remains. The respondent provided documentation where the complainant refused embalming, given that the remains were to be cremated. It is not known if this was an intentional position of the complainant regarding refusing embalming but demanding the viewing. However, it appears respondent was not comfortable and would not allow family of decedent to view the remains without preparation, given that they were to be cremated, and states this position was for public health concerns and attempting to follow the CDC guidelines. This was provided as part of the complaint response. Given such, to me, it does not appear that there is a violation of any professionalism, given that respondent has reason to believe that decedent posed a COVID concern, and there was no documentation negating this concern provided either by the hospital or the decedent family. Given that, my recommendation was to close this matter.
The investigator by chance speak with the doctor? Because I know there was some notation here that the doc. Okay.
Did not speak with the doctor.
I'll move that we accept council's recommendation.
We have a motion by Mr. Berry to accept council's recommendation for closure. Do we have a second?
Second.
Second by Mr. Harris. Any other discussion? All in favor say aye.
Aye.
Opposed? Motion carries.
Thank you. The next complaint 5, it is number 2021032261. Here the complainant is the niece of the decedent, filing this complaint against respondent, who is a funeral director, stating that she would like the cremains of her aunt to be released to her by the respondent. An investigation was conducted. The investigation found the decedent died in 2017. The next of kin with right of disposition is the daughter of the decedent. The daughter made arrangements for cremation with the respondent, but could not pay the entire cost at the time of contracting. The payment for a later date was arranged with the respondent. The decedent was cremated, and respondent informed the daughter for pickup. The daughter would not return the phone calls of the respondent. The daughter never paid respondent either beyond the $50. Excuse me, there was a $50 that was paid up front. I should have mentioned that earlier. The complainant contacted the respondent requesting the status of the cremains, stating that family members had provided the daughter funds for the cremation. The respondent stated that the daughter would not pick up the cremains and had only paid $50. After this conversation, the respondent states that the daughter contacted him and threatened legal action if respondent either took payment for the cremation or released the cremains to anyone else but her. The respondent then informed the complainant that and the investigator that the daughter is the next of kin but will not pick up the cremains and has since actually moved out of state. The respondent further states that it has never stated that the payment must be made prior to releasing the cremains and has encouraged the daughter to come pick up the cremains. The complainant states that her grandmother, who is the mother of the decedent, is requesting the cremains be released to her and transported to her in New Jersey. The respondent maintains that the daughter is the next of kin and with the threat of legal action cannot release the cremains to the complainant. My recommendation here, though it is to close, that the complainant does not have the right of possession of the cremains, and determination otherwise would be more for a decision of the court to decide pursuant to the statute that I listed there if the complainant so choose to do that.
I agree with council on that, and we'll make a recommendation that we close. Second.
I have a motion by Mr. Berry to accept council's recommendation for closure and a second by Mr. McKinney. Is there any further discussion? I do have one question before we call for the vote. Mr. Glandorf, since it has obviously been longer than 180 days since the death and the cremation of this individual, would it not be within the funeral home's prerogative to do with those cremated remains what they deem most appropriate, since the individual in question will not respond and pick up the cremated remains?
I think there's probably an argument that they could. There's probably an argument that they could. there's another side of the argument that says that the next of kin is known, and the next of kin has made the wish as to the disposition of what should not be the disposition of those cremains. So I know that the funeral establishment is in a difficult position, and that if I think that they would have a risk of a potential lawsuit out there if they did provide those to anyone else. Unfortunately, in the example, if nobody had come forward, if that daughter, if he could not get in touch with that daughter, the person for right of disposition, then I would agree with you that I don't think there would be a risk at that point in time.
Thank you.
Yes.
One other question right there. Did the respondent try to get the address of the daughter to try to get those mailed out to her to release the risk from them at least?
I don't know if he actually has her. I don't know if he does or does not have her address. I know that from our investigation, is that his statements were that he has attempted to keep in contact with the daughter to come and pick them up to her. So I'm not sure if he's attempted to mail them, ship them to the address. I think there may have some concerns of doing that. The daughter apparently came back into the picture after he spoke on the phone with the niece, because he was speaking with the niece, and because the family had raised money for the cremation, he indicated that it had not been paid for, and that, I'm going to make an assumption here, is that the niece contacted the daughter, who then went back and contacted the funeral director and said, you will not talk to anybody about the release of the cremains, what was paid for and whatnot, with anybody else. And so I do not know. I do know that he knows that she is out of state. She's moved out of state. I don't know exactly where, or if he's attempted to.
I'd also probably say that the funeral home would have to have consent from the next of kin to do the mailing. So
Right.
As you said, the funeral home's really in a difficult position.
Yeah.
They are.
Any further questions regarding this matter? If not, all in favor of the motion and the second, please respond by saying aye.
Aye.
All opposed? Motion carries.
Next one on the legal report, 0210351. Here the complainant is the grandchild of two deceased grandparents that submitted a complaint against the respondent, which is a funeral establishment, and they state that the location of their grandparents' grave and headstones are missing from the cemetery / final resting place of the grandparents. The respondent states that it does not own the cemetery, however, that the prior owner, who's now deceased, was previously involved in the cemetery in the years past. I'd say involved, I think, probably likely part of the establishment of the cemetery in the past. And further, that the grandparents were buried approximately, one was buried 60 and one was buried 30 years ago. However, as part of the response, the respondent stated that they offered in reaching out to the complainant and assisting them in attempting to locate the burial plots. A search of our licensing database on the cemetery indicated that it's not a registered cemetery at this point, and further search of the cemetery found that it's known to have been abandoned, and it is currently owned by the cemetery itself, meaning it's not owned by the funeral establishment. And it does have a property tax card of tax-exempt or religious status. It appears that for the plots purchased, persons have been continued to be buried over the years because they have plots purchased. And this is generally a historical cemetery that's over 150 years old. Given that the respondent funeral home has no legal responsibility over the cemetery and has offered to assist as a kind gesture towards the complainant, I don't see that there's any violations that could be found here, and my recommendation is to close.
Motion to accept council's recommendation.
Motion by Mr. McKinney to accept council's recommendation of closure, and a second by Mr. Berry. Any further discussions? If not, all in favor say aye.
Aye.
Opposed? The motion carries.
The next one is 03620. The complainant is the family of deceased who submitted a complaint against respondent, which is a funeral establishment, stating that she was provided an urn with the cremains of another person and not that of her husband. The complainant states that a representative did provide confirmation that the cremains were that of her husband, but however, in her complaint, she still feels that there is the sadness of, she feels the deepness of her sadness. The respondent submitted a response and admitted that they initially provided the complainant with the cremains of another person that were placed in the same type urn as complainant's husband. Both similar urns were ready for pickup the same day. The complainant was the first to pick up the cremains, and it was not until the family of the second decedent came to pick up their cremains that it was determined that the complainant was given incorrect cremains. The complainant was notified and brought the cremains back to the establishment, stating that she was, excuse me, I skipped one. I'm going to back up. The complainant was notified and brought the cremains back and was provided the cremains of her husband. However, after some time, the complainant came back to the funeral establishment, stating that she wasn't comfortable that the cremains in her possession were that of her husband. So, an agent of the funeral establishment accompanied her to her home and verified the cremains via the identification marker from the crematory within the cremains. This complaint was submitted after that verification was made, so it was submitted after those events had transpired. Further, respondent has indicated they're arranging the shipping of the cremains out of state for final disposition at the request of the complainant. My recommendation is based off the fact that they did provide the incorrect cremains to the complainant, and that is a recommendation of a $500 civil penalty for unprofessional conduct in providing those incorrect cremains with authorization to settle that matter.
I'm sure this has probably come before the board before. And my assumption is that the 500's consistent with past practices regarding mixing up cremains. Can you address that at all?
I did not go back to look at a historical civil penalty determination on a like-kinded complaint. We do not have a database of that. I do not have the institutional knowledge to remember. I apologize.
It's okay.
I wish I did. I did look at the difference between some of the previous violations, such as the history of this respondent shows that we had issued them civil penalty violations previously in the amount of $200 several times. One of them was for a FTC rule advertising violation. Based on that, I believe that there was also previously a civil penalty, for $750. This is 16 years ago, for an incorrect name in an obituary. And so I thought that the $500 was me trying to determine what would be an acceptable or recommendation for you all. I thought it was more egregious than a violation of a advertising. I'm not sure. It appears probably it could be as the same nature of having the incorrect name in an obituary, since that's permanent. You really cannot undo that. That was at $750. I did feel that the $500 was for the fact that there was unprofessional conduct, though it's obviously a mistake. But it's one that could have been avoided since they knew they had two urns. And I did take into consideration that it appears that this was after the fact, and they did go to her home and verified with the permanent marker so that she absolutely knows those are the cremains of her husband. But that civil penalty was for the for that conduct, and then the generally as we do the ramification blatant for that.
Mr. Berry, if my memory serves me correct, it's probably been a while since there's been one like this. There was one years ago, my first go around, where the urn had been buried and it was the wrong person. So This is probably pretty close. I don't recall exactly what it was, but it was probably at least this amount. But this, thank goodness, this doesn't happen very often.
I'll make a motion that we accept council's recommendation.
We have a motion by Mr. Berry to accept council's recommendation. Do we have a second?
So move.
A second by Mr. Harris. Any other discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
The next one that is number 8. It is number 2021037001. Here the complainant was an attorney who submitted a complaint on behalf of the brother-in-law of the decedent. The complainant states that the respondent funeral home contracted for services to include the shipment of decedent to his home country of Guatemala. However, that was never done, is the allegation. An investigation was conducted. During the investigation, it was found that the respondent owner of the establishment was contacted by a funeral director to associate with, and we're going to call him, this person, the associated funeral director, in order to embalm decedent and arrange shipment to Guatemala, basically using the funeral establishment services. The associated funeral director had previously surrendered all licenses after the facts of this complaint stemming from similar issues. So that will not be brought up today on the associated funeral director. This is solely at the funeral establishment. The body of decedent was brought to the respondent funeral establishment on August 5th, 2019, and arrangements to ship were made for approximately August 22nd. The respondent states that they were informed by the associated funeral director that the remains of decedent were shipped on or about September 4th, 2019. The associate funeral director was not available to confirm this statement during our investigation. On or about March 6, 2020, the respondent owner states that a second funeral establishment, we'll call them Establishment 2, contacted him stating that the remains of the decedent were in fact at his funeral home, but they quote, belonged to the respondent owner establishment. These are the remains of the decedent brother-in-law that we're talking about. The brother-in-law's decedent. Respondent states that he was unaware of this until contacted and arranged for the decedent to be moved back to his establishment. The respondent states he attempted to contact the brother-in-law with the contact information he had, but to no avail. And then further, the Mexican consulate for assistance. However, there's no explanation on our file investigation as to why they would not have reached out to the Guatemalan consulate. And I'm not sure if that's a mistypo or whatnot, but we never got clarification on that. However, the respondent made contact with the associate funeral director and stated he wouldn't, and the associate funeral director stated they would not cooperate with providing updated contact information on the brother-in-law. The respondent determined that due to the decomposition of the remains, they could not be flown to Guatemala. Could not be. There was also an issue of air travel restriction at the time. This would have been at the beginning of the war for COVID. The respondent communicated with the associate funeral director regarding further arrangements without a clear understanding as to who actually had right of disposition authority, as the associate funeral director stated and continued to state that he had the power of attorney from the family. However, he never produced that during our investigation and would not produce anything. The respondent made the decision at that time to bury the remains of the decedent, paid for it themselves with the burial and the headstone. This information on the location of the plot was sent to the associate funeral director to provide to the family, who was the brother-in-law, and then also to the complainant attorney. Based on this scenario, my recommendation to this funeral establishment is a letter of warning.
Landorf, do you know if the respondent funeral home was compensated in any way for their role in this matter?
I do know they were not.
They were not.
They were not by the family. It was the associate funeral director who was compensated by the family.
We know when the remains were moved from the respondent funeral home to Establishment number 2? And who moved? I'm assuming the associated funeral director moved them,
Right.
but do we know when they were moved?
I can only surmise that it would have been between that time of it, where they were brought in on August 5th and they were made to have been shipped out around September 4th. It would have been around that time frame that they would have been moved out, because this respondent was present at their own funeral establishment and knew that they were no longer there, that they had been moved by that associate funeral director. We will see a next complaint today that is going to talk about that the next funeral establishment. So
Respondent had the original contract with the family.
yes, if you would look at the paperwork that the associate funeral director did, it was on this funeral establishment's documentation. That statement of funeral goods and services and what they were provided was on was on their documentation. This establishment allowed that associate funeral director, who was licensed at the time, to come in and use their establishment and their facilities with this family, and it was to ship those remains overseas. And this, to break it down even more, this funeral establishment, this owner was told by and under the belief that had actually been done, that they had been shipped to Guatemala, and did not find out that that had not been done until a later funeral establishment stated, "I am in possession of the remains that actually belong to you." And I will say that we'll see it later, that funeral establishment was slightly what I would consider to be absent as to what remains were in their funeral establishment at the time. So it appears to me that this funeral establishment director was lied to by that associate funeral director. When he found out about that, there was an attempt to ship those. There was an attempt of, can we ship these remains overseas? We have photographs. There was no way that these remains could have been shipped overseas in that state. To go even further, there were text messages that I saw with the associate funeral director stating that the family members would not agree to a cremation for religious purposes or whatnot. So based on that, I know that this funeral establishment did not feel that they could even cremate, just to cremate and then to attempt to ship over to Guatemala. And then with the decomposing nature of it, in the state that they were in, decided to, without having further communication with this associate funeral director, or who were the family members, how do we get into contact with them, decided to bury the decedent and provide that information back to the associate funeral.
This associate funeral director ever been in the employ of either one of these firms, either the respondent firm or Establishment 2, or did he have a formal working relationship with any entity at this time?
We don't think as an employee, but more as in a trade associate director. I think I said that correctly.
Contract, labor
yes, contract, and that had been and with several funeral establishments, I think, around the area over the years. So they were familiar, yes, with this individual.
I guess just so I understand a little bit better, did the respondent have an agreement to go ahead and bury, or was that upon state authorization? Or
the respondent states that, with no real particular, kind of see me moving here because I have to say something that I don't know if it's legal or not, but so they say that under the laws of, or the ordinances of Davidson County, that they were authorized under the municipality to dispose of those of the remains that were in that decomposing state as they were, I think, of a health issue. But honestly, I did not research into whether or not that was something that they could do based on based on what the municipality says that they could have been authorized to do. I didn't go that far.
After the original mess with this associate, this establishment, you believe that they did the best that they could do under the circumstances that they were handed?
I appreciate that question. Yes, I mean, it seemed from all of the statements that were received is that this respondent did not know until they were contacted by the other funeral establishment that those remains had not been shipped out. And then when they were contacted, they immediately went and recovered those, and then continuously attempted to make contact with the associate funeral director to get contact information for the family to do what the associate funeral director had said they'd already done, which is either ship those remains or do something with them. And then when that communication failed to a certain point, they did the only thing I think they thought they could have with the remains in the state that they were, which was to bury them, and then provide that information to the associate director to give to the family member, since he wouldn't give them the contact information. They had contact information, they could not get in touch with them with the contact information they had. The phone numbers, the address, nobody was there that could speak with them. It wasn't until this attorney has come forward as representing them that we've had clear contact information with that family.
Mr. McKinney, I think you said it perfectly. This funeral home did the best they could, so I make the motion we accept legal's recommendation letter of warning. In my opinion, I think they ethically did the best they could in what they were given.
Well, second.
We have a motion by Mr. Harris to accept council's recommendation of a letter of warning, and a second by Mr. McKinney. Any other discussion? All in favor say aye.
Aye.
Opposed? Motion carries.
Next one, number 9. This is going to concern the next establishment that we had just as part of that. Here, the complainant is the same as above. It's an attorney, so they also filed a complaint against this second establishment, who filed a complaint against the respondent funeral establishment, which is named as Establishment 2 in the above complaint we just talked about. The complaint against Establishment 2 above indicated the respondent allowed the associate funeral director to use its facilities and allowed bodies to decompose greatly while in its care. The respondent was subject of a previous complaint regarding a connected matter in this case, which were, you have those case numbers there, 2020-0193-01 and 17091. During an investigation of those cases, the remains of the decedent above were identified at that location immediately after the investigation. The respondent in this case and respondent 2 in the case above returned the remains to the original funeral establishment. The respondent in this matter was already issued a civil penalty via consent order for the same facts as involving the decedent. And so I say all that to say is that this respondent here has already been disciplined for its actions that are complained about now. And as such, I would recommend that we close that. Respondent's already disciplined for that matter in those 2 cases above. And just for edification, there were, in that matter above, there were 4 remains at that funeral establishment that had not been, they were not properly identified. One of them was the remains that we're speaking of here, and they were issued a civil penalty, I believe, in the amount of $15,000, and are currently they did agree to that discipline of that. And then they provided us with a status update that they know of those other remains that were in their establishment.
Was this the person that filed this complaint, were they aware that this had already been taken care of? Or was this complaint filed kind of in the midst of all the other?
This complainant was not, this complainant attorney was not aware of, they were aware of the discipline of this establishment. I don't think they were aware that their decedent was there. They thought that their decedent was another decedent. It was, I mean, honestly, because they were not marked It wasn't until we went back into the file, and there is, from one of our photographs, you can see the first and last name of this decedent, that we realized that is this decedent that we're speaking of, because we had no idea who they would have been. So we did put that together. So they now know that. They would not have known it at the time, but we already disciplined them for this exact set of circumstances, which was, in general, which was allowing the associate funeral director to use its facilities and store remains that were decomposing and were not properly marked and had not been disposed. Their disposition was questionable at the time.
Make a motion to approve.
Second.
A motion by Mr. McKinney, to accept council's recommendation, and we have a second by Mr. Berry. Any further discussion? All in favor say aye.
Aye.
Opposed? Motion carries.
Thank you, gentlemen, for allowing me to meet with you this morning, and I appreciate your patience. I will, as the chief counsel, let you know that it was sad that Liz Bendel was transferred within the department. I've been with you all so long that I cannot tell you how many times I've had to have this conversation and and apologize that we've lost your board attorney. I think Liz did a good job, and I appreciated working with her, but she was allowed to transfer within our division, and we are in the hiring process of looking for someone to replace Liz. I will be the attorney that will be presenting these to you and working with Robert on a daily basis until we do that. It is always my goal to find an attorney who I think will work well with this board and with Robert, because you all I think deserve the best in somebody who has the temperament to work and present these things, and understand the sensitivity of the nature of the things that you all have to deal with in your profession. So I think we've identified some. I think we're going to probably get one of these that we've identified. And so I hope to, in the very near future, be able to come before you all again and introduce that person to you. So thank you.
Thank you, Mr. Glandorf. We appreciate your long service with the department, and we certainly concur with your sentiments about Ms. Bendel. This time we'll call on Robert Gribble, the Executive Director, to give his report.
Thank you, Mr. President. Good morning, board members. First is the Office of Internal Audit, the review of funeral establishment inspections completed in 2019. Of course, you've been emailed this. This audit was issued on July the 15th, and you've been emailed the audit. But to make it part of the record today, obviously we're glad that, well, first, for those that might be viewing, it's the Office of Internal Audit completed a review of funeral establishment inspections completed during the calendar year of 2019 by the Board of Funeral Directors and Embalmers. The purpose of this review was to evaluate whether the board is properly and timely completing annual inspections, and the objective of the audit was to ensure funeral establishments were inspected in accordance with TCA 62-5-208. And specifically, the Office of Internal Audit completed the following. 1, to ensure all funeral establishments received an inspection during the calendar year 2019, and 2, for a sample of inspections, ensure each inspection was conducted timely and proper inspection documentation was retained in core. And if you go to near the end of the audit, really at the end, it says the conclusion. The Office of Internal Audit's review indicated that the board has a sound inspection process in place and inspection records were complete and are in good order. No material discrepancies were noted during the OIA's examination, which as a program director, you're tickled pink, tickled to death, whatever you want to say, very happy to get that report. But that is due to the work of Ms. Bohannon and the 3 gentlemen that are sitting back in the back there, along with some ladies that are upstairs working today. These investigator and the field reps upload those reports into core. Ms. Bohannon checks them, and it's done with the assistance of some of the people upstairs in our board office as well. So we're thankful to get that and very appreciative of the team that we have in place that did an excellent job, because it's just executive management noted that there are not many audits that end with no findings, and this was one of the ones that did, so we were very happy about that. Licensee report, a report of establishment and individual license administratively approved by the executive director pursuant to the board authority for the period of June 1, 2021 through July 31, 2021, and you have those before you as well. There are no closed establishments we have to report to you today. Disciplinary action report is a report of consent orders that have been administratively accepted or approved by the executive director pursuant to the board authority, and as these were reported on the May and June 2021 regulatory board's disciplinary action report. And you have a list of those as well. All those were reported in June, but so we said May and June because the last time we given you a report it was on the April, and so that someone later looking back would not think we omitted something, we did include May, which had 0 reporting on it, because these that are listed were reported in the June month. In the complaint report, as of July 28, 2021, they were 18 funeral director or embalmer complaints and 18 establishment complaints for a total of 36 complaints. That concludes my report. I'd be glad to answer any questions that you might have.
I'd personally like to congratulate you and the whole team for a job well done.
Thank you.
Second.
No further questions for Mr. Gribble. We'll entertain a motion to accept his report as presented.
So move.
Second.
We have a motion by Mr. Harris and a second by Mr. McKinney. Any other discussion? All in favor say aye.
Aye.
Opposed? Motion carries. We have 2 establishment licenses to consider today. And the first one before you is Blunt Mortuary Services, LLC. You should have received a copy of that application in your email, and there is also a document that has been presented that has some updated information in it. So we welcome Michael Harding to the board this morning, and Mr. Harding, we will turn the floor over to you to give us what information you would like to share.
In order to work with the funeral homes in that region, it seems to be a service needed. We have a mortuary service there, but I'm hoping to be able to expand into a new venture. When the inspector came out, I was probably a little bit unprepared, so I went ahead and done more updated. I'd had some shipments come in, and there was some freight that had been piled up in one little corner, and we cleaned it up and got it positioned where it was supposed to be. But I just want to say I appreciate the board allowing me to come in and sit down and talk today. Do you have any questions or anything for me?
I notice, Mr. Harding, from your original application, you have added some additional preparation room facilities that have granted you access. So could you touch on that just briefly? I think the first one in your application was Hatmaker Funeral Home in Lake City, but I noticed that has been changed to their Rocky Top location, and Lake Hobbs and McCammon Ammons Click have been added. Could you just speak briefly to that?
Yes, sir. I thought about that a little bit, with not having my preparation room constructed at this point, and I'm working on doing that. It would be easier, to section it off where I can, if I got a call, let's say in Kentucky or somewhere like that, I'd be able to save them a little driving time by utilizing the Rocky Top location. Or I could utilize the Lake Hobbs in Athens for anyone south. That would help if they were coming to retrieve or pick up the deceased themselves. The Blunt Mortuary is just down the road from McCammon Emmons and Click Funeral Home on the same street. So I thought that would be just a good place for me to be able to have a good holding for any places that needed my more personal touch, because I do a little embalming. I travel to a lot of funeral homes and embalm at those locations now. I have for the last couple of years, and been blessed enough to do a little over 400 at this point in time. So I'll still be doing those locations. So just utilizing one of these other locations is just a if I need location, just to have that availability. And these guys have been good enough to me to allow me to be able to do that, which we have 2 letters, and Larry Hobbs at Laycock Hobbs said he would send his in as needed.
You already have a trade relationship then with any or all of these 3 firms?
Yes, I am the individual embalmer for the Laycock Hobbs, and I do some work for Hatmaker Funeral Home in Rocky Top and some at the location in McCammon Emmons. Laycock Hobbs lost their embalmer about 3 years ago, and I stepped in probably about 2.5 and started doing all their preparation work. Along with, I've got 4 funeral homes, I'm 100% their embalmer already. And then I got several like McCammon Emmons and Hatmaker where I go in and do work whenever they're needed.
I would make the motion that we approve. No further questions.
How long do you anticipate it being before you get your preparation room completed?
My hope is I'm trying to do this debt free and go in as quickly as possible. We've got all of our permits. You don't have, but Mr. Gribble has a plat from the city. They have approved all permits for construction to start at any time. I have the full blueprints with me if the board would like to see them. We're hoping to start construction just in the next few days. We were kind of hoping, of course, COVID slowed us down, and then also the price of material has kind of put us in a little bit of a binder. And so we're hoping that with the price of material starting to come down some, we can at least get some started. But to answer your question, Mr. McKinney, I'm hoping to be done by the first of the year.
I think there will be some additional questions, but we have a motion on the floor by Mr. Berry to approve the application, and we'll entertain a second.
Second.
We have a second by Mr. Porch, and now we'll give opportunity for any other discussion or questions that might be on your minds for Mr. Harding. Harding, how long have you had the property at East Broadway under lease?
Almost 18 months. Well, it was a year ago, March. So we're looking at probably about 15 to 16 months.
What is the history of the ownership of that property? And I'll tell you where I'm going with that question. I just noticed in some of the original pictures that were sent before you had the opportunity to do some housekeeping, that there were funeral merchandise items in some of those photographs, some adult caskets and what appeared to be a child's casket, and looked like what was a Vantage grave liner in one of the pictures, and then some other funeral-related items. And I was just curious about the history of that property and those items that were stored there, and what the intent of having those items there were for a mortuary service.
They're there not for the mortuary service. I also own another company called Fiesel Funeral Supply, which I go out and set up tents and chairs and steel burial vaults and some Vantage or Polyguard products. Those are there. My warehouse is down on Morganton Road for that company, but the administrative office is there because that's where I rented the facility to begin with the hopes of possibly putting in a mortuary service. Those items are in a corner, and there is a construction of a wall that will be separating that bay, there's 2 bay doors. One will be utilized for the mortuary service and one utilized for the funeral supply. But there's 2 or 3 caskets. It's just convenience. There's also, I don't know if you got a picture of it, a couple of tents and a couple of lowering devices in
You
there.
see a
to
lowering
save some
device
trees.
in
Yes.
one of the pictures.
Yeah. So there, but in the project, there is a wall that's going to divide the two businesses. Just one administrative office, but 2 separate businesses.
Primary purpose of your lease for the past 16 months or so has been as a warehouse facility with the idea of at some point applying for the mortuary service licensure.
Yes, small warehouse, because all the vaults and the caskets, I got 130 something solder caskets down on Morganton Road, along with 30 steel vaults, and there's no room in there for all of it to be under one roof.
President, may I ask a question administratively?
Certainly.
Mr. Harding, I know that the application has 1900 as the address, 1900 East Broadway Avenue. And then from the photograph, it appears that there's another office that appears to be addressed as 1902. Is this one building now all 1900, or is it 2 separate addresses? And is the office actually located in 1900 or 1902?
The owner of the building had 2 separate rooms, and there was a gentleman in the 1902. We utilized the same mailbox. It is he does receive mail from the 1902 address. He passed away, and when he done that about 60 days ago, I got the opportunity to take that over, and that's where my office will be in there. Now, the 1902 at the post office will be discontinued, and it will just be one 1900 address. The only reason I haven't done that so far was I was making sure with me having the Feazell administration there office, did I need 2 separate addresses for each company, or can I just use the one since it will be one building? There's no doorway between the larger section to the smaller office yet, but during construction there will be.
I noticed the mailing address for the entity on your application for the LLC is 420 Continental Drive in Maryville, and that application was electronically signed by Chad W. Hampton as organizer. Is he your attorney or a business associate, and that is his address, I'm assuming, or?
The 420 Continental Drive was the original Feazell address, so when I done the LLC for Blunt Mortuary, that was the address used at the time. And so but Chad Hamilton is my attorney that did the LLC.
Thank you.
The only thing that obviously I don't have any problem with your business that you're putting in. The only issue that I have at this point is you not having your embalming room, your preparation room put in, because everything's kind of, as you said, straightened up, cleaned up. Everything looks good. That's the only issue that I have is you not having that preparation room facility already in place. Because if I vote to approve this, then I'm kind of going out on a limb that you're going to do what you have planned to do. So that's the only issue that I have.
I definitely have plans to do it. Like I say, I've got full blueprints over here. Of course, that's a cost. I've already got lined up for electrician, lined up for the plumbers to come in whenever that part gets done. We're getting ready to start. We got to raise the floor a little bit for the sewer line to be able to connect in for the preparation room, and then we're also looking at, of course, a walk-in cooler. And I've got to get all that up and running and going. Of course, I've ordered a Mini-Max cot, and we know how equipment is. It's on back order to about October or November. So a lot of this other equipment is too. But I'm hoping to be done quicker than before the first of the year, but that is my deadline. And the permit for the city, construction permit, is only a 1-year permit. So after that, I'd have to reapply and have to go back through all the hoops through the city.
I'm assuming you have money already tied up in those permits and blueprints and all such as that.
Yes.
All that wasn't free. You've already
No.
you've already paid for that.
No, the investment's being started. I've bought 2 vans. I've got 1 cot already in hand. I've got a second one I got to pick up. I've got an embalming machine, and I've got 1 table, and I just got offered another porcelain table the other day. I'll have 2 stations in the preparation room, even though it's just me. Because, if it grows and does what I'm hoping it'll do, then there might be others one day.
Until your preparation room is in place, is your primary preparation room going to be there in Maryville at
Kimmon, Emmons, and
Kimmon,
Clinton.
Emmons?
Yes. Like I say, the majority of my business at this point is traveling to other locations, and that's still going to be that business. I need the license to be able to do the transportation, the removals, and some out of town services. And I can advertise and start hiring help.
Embalming room does have to be inspected, right, before you wouldn't have to notify the board that is prep.
Typically, that's what happens. That the person will notify the board that the embalming facility is completed and ready to be used, and then the field rep will go out and do an inspection.
And then all 3 of these others are going to have to be inspected too, I'm assuming.
Well, and that's what I was going to bring up too. The application only lists 1 location. Does that need to be redone to state all 3 locations that he's?
Mr. Glandorf is nodding.
For the document, in order for the board to, if there's an agreement that we will approve a license based on X, it should be in the application, or I don't know this. I don't know if there's allowed for supplemental information to be attached to an application, but just administratively it needs to be in there so that we all do know and we don't have confusion as to where it's at,
I think that's what I'm struggling with. There's so many different pieces here, and that being one of them. So that's why I raised that question.
Obviously, we have, several storefront funeral establishments that's for, funeral services, cremation services, and of course they don't have on-site preparation rooms, but they're nearby. And as far as I know, they just use 1 location. I guess I'm looking at Mr. Gribble for some confirmation of that. I don't remember. And I guess what I'm getting to is the 3 places is different. I would feel better if you just used 1, but I understand why you are doing the 3 as far as convenience where people are coming from. I understand that, and I certainly don't want to hold you to any higher standard than any of these other storefronts that we've approved. So I guess, Mr. Gribble, do you know of, have we, has the board?
You can ask the field reps. They would have probably a better memory than
Is
me,
there a mortuary service that utilizes more than 1 preparation room? Do most of them just have their own, and that's kind of it?
And they may be able to shed light on this. I can't think of any mortuary service that doesn't have their own preparation room. Now, like you said, we've got several storefront funeral homes or funeral providers of funerals and cremations that are in office complexes and things of that nature. I don't know that we have, but any funeral home that doesn't have a preparation room, then they furnish us with a letter saying what preparation room is being used or who's preparing their decedents for embalming and preparation remains. And to my knowledge, is just 1. But Don't see anybody say anything different, so I guess that's
Roy, we're looking at you. Jimmy, David. Okay. He's thinking that maybe there's one in Memphis, that there's.
he uses more than.
Please approach the bench.
I know of one that's named a mortuary service that doesn't have a preparation room. Is that your question?
That was one of them.
That was one of them. And how many preparation rooms do they use?
They just use one.
Okay.
At a different location. What
Okay.
they do there.
Okay.
Seems to me we'd have to have that in our rules that specifically required the use of one preparation room. I can understand why he's doing that, but it seems like I don't see how we could
what you call a gray area.
yeah. I think as long as those are licensed facilities and there's not any issue with those facilities and they're inspected in a timely basis, and I would think that regardless of whether you use one or three, it could even be a situation where you have one location that's very busy and going to be very inconvenient for him to bring a deceased there to embalm and has to use the other facility. So I can think of other reasons other than geographical reasons for doing it as well. And again, as long as this preparation room is going to be inspected, and if that can be part of the approval motion, I think that we can safely assume that it's going to be operated in a very professional manner.
Dribble, what is the cost and the process for Mr. Harding to amend his application to include these changes that we have not seen until today?
Process would be you could email the information to us or hand it to us, which may be in the packet. I'm not sure. If he mentioned one other one that
is in the packet.
it may not be in there. As far as cost, there's no. I mean, if it's done at this time, or if there is a motion that passes to approve it, and it's made where he'll have to furnish something, then I think he just furnishes a document before a license is issued, document or documents. If the application were to be denied, then you start again at ground zero and go back through the whole process and pay another application fee.
Glandorf, can this board move to make this packet that Mr. Harding has presented to us today a part of his application?
I know of no rule that would prohibit you all from doing that.
How long is, remind me, how long is his application good for?
Good for 6 months from the time that we received it, correct, Mr. Bohannon? It expires in 6 months. I want to make sure that the board understands this, because I always want to be transparent about everything. When we have an application like this, now as far as going to the funeral home at Hatmaker Funeral Home in Rocky Top, and Mr. Shannon, you correct me if I'm wrong, but we don't typically go do an inspection there based on this application, because we've already inspected that facility. As Mr. Berry said, it's already a licensed facility, and I'm of the belief that you go when you need to go, but you don't make unnecessary trips to hamper someone's business or operation, or for them to think that you're harassing them or being burdensome to them. So we don't, like when Mr. Harding made this application, Mr. Shannon didn't go to Rocky Top and inspect that facility as well, but he went to Mr. Harding's facility and did the inspection there. Is that correct, Mr. Shannon?
That would have been my understanding, that these have been inspected and are in good working condition. But my concern would be that when he opens his own preparation room, that would be inspected, and certainly the board would be notified so that could be inspected.
Part of the approval process, couldn't it?
Yes, we can, there is a rule, yes, that says that it shall be inspected. As part of the approval process, we could in legal create a document, if that's what you're, I'm not sure if that's reference to, but
More of a question of whether we can make that as part of the motion that ensure that when his opens up, that it would be inspected.
yes, you could say that this board could, in approval of the license, is that a condition is that they cannot use it for those conditions until the room is built and inspected and approved by the administration here.
I'll amend my motion to include what he just said.
And for transparency, there is a $200 reinspection fee. So that would occur at the time we come out and do the second inspection. And that's by rule of the board.
Gary, while you are amending your motion, would you be agreeable to including as a part of that amendment that the packet that Mr. Harding has presented today be made a part of his official application for licensure?
Yes, sir.
All right. We have an amended motion on the floor. Does everyone understand the terms of the motion? Do we have a second for the amended motion? There being no second, the amended motion dies.
I'm still thinking.
I can't wait forever, Mr. McKinney.
You're supposed to auction it off. That's what David Murphy used to do.
Well, I'll open the gates one more time. We have an amended motion on the floor.
So if we don't approve this amended motion,
We go back and vote on the original.
then it goes back to the original, correct?
Right. Yes, we have to deal with the original motion if we don't vote on the amended motion. I do know from Mr. Bozeman's remarks that there is one mortuary service in Memphis that does not operate presently its own preparation room. Is that correct, Mr. Bozeman?
May I say something?
Sure.
We've got one in Knoxville also, Fred Adamad, East Tennessee Mortuary Service. He's in the garage at Click Funeral Home
That's true.
in Farragut, or Middlebrook Pike.
Yeah, that is true. As personally, I just feel it's, I would not want to hinder a new startup, and I just think the state that we live in this current time is trying to ensure that businesses are able to open and compete. So again, I just feel like it's the right thing to do.
I'll second it.
All right, we do have a second to the amended motion by Mr. Porch. Is there any further discussion? Not, all in favor say aye.
Aye.
All opposed? Motion carries. Congratulations, Mr. Hardy.
Thank you, gentlemen.
Next application is Kimmon's Mortuary Service. Kimmon's, forgive me, is it Sherrod?
Yes, sir.
All right. Very good. Well, we welcome you to the board today. We have your application before us, and if you would like to address the board and share any comments that you would like to share, go right ahead.
Well, thank you for the opportunity, but I don't have anything to share right now.
All right, so we'll open the floor up to the board members to ask any questions that you may have regarding this application. Kimmons, I notice as a part of your application, you have included a general price list and a casket price list and an outer burial container price list. So my assumption is that you plan to offer services and merchandise to the public in addition to serving as a mortuary service for trade work?
Yes, sir. But primarily retail. I do some trade work also.
But this is primarily for the public. Okay. 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 The name kind of confused us a little bit.
I apologize.
Okay.
Statement of funeral goods and services that we received, is this the actual layout that you're going to be using? Okay. Mr. Gribble, you correct me if I'm wrong, but there's not a place for the director to sign this binding contract, and there's also not a place for the purchaser to sign this contract. Is that required?
Board has adopted the funeral rule, and the requirements of the board would be dependent upon the funeral rule. It's my understanding that although it might be a best practice or a good practice, that there's not a requirement for it to be signed by either party, which I can understand why an establishment would want it signed, and I can understand why a consumer would want it signed. And I would need to check that, but again, these three gentlemen in the back deal with it every day. Mr. Bozeman, you want to be the spokesman again?
I think this was your inspection, though.
I can pull the funeral rule up and see. You know, I thought the funeral rule required that the establishment have their address and phone number on the casket price list and outer burial container price list. So I went back and looked at it. It doesn't. It requires it on the general price list. So I have to go back and refer to the funeral rule from time to time myself to really make sure that.
There's also not a disclaimer about X amount due days, got to be paid, etc. To me, there's just some missing pieces there. That's why I bring that up. I could be wrong on my thinking.
I understand the question. Could you comment?
Yeah, so on the statement of funeral goods and services, there's not a place for the director to sign nor the purchaser. Is that a requirement on our statement of goods? Because to me, that is a legal binding document.
Not that I'm aware that's a requirement. It would be prudent on the establishment's part to do that.
Kimmons, I note that your arrangement for preparation room facilities and cremation facilities is with Taylor Funeral Home in Dixon.
Yes, sir.
And as I look at Google Maps, that appears to be about 70 miles away from your location in Murfreesboro. Do you foresee any issues with that distance? And a question that in my mind arises out of that, if you're doing trade work through the mortuary service component of your business, where will you base your mileage charge if someone asks you to deliver? If they think they're calling a firm that's located in Murfreesboro, but actually you're going to Dixon, Tennessee for your preparation work, and then you've got to transport a body, we'll say, to Memphis, Tennessee, what will be the origination point for your mileage calculations? Will it be Murfreesboro or will it be Dixon?
Thank you.
I didn't think about the charges where it would originate from, but I live in Nashville and I do trade work for Taylor. I guess I got to think about what's the best honest answer for that.
If I see, for example, if I'm a funeral home in Colorado, and I see that you're in Murfreesboro, Tennessee, based upon the information in this application that your address is Murfreesboro, Tennessee for your mortuary service, and I have a death that occurs in Murfreesboro, Tennessee, and I think you're right there, so I'm going to call you to handle that for me, and that's what I'm wondering is how you'll handle situations like that.
I believe the best practices will charge for where the location I'm located in Murfreesboro. That's not their issue that I have to make certain arrangements.
Good answer. Will, the place in Murfreesboro, now there is no place there for remains to be taken, right? It's just an office?
Yes, sir.
Okay.
Facility shared with anybody else?
It's an office suite, but I have my own office suite.
So signage will be located where?
It'll be on the front of the building. Oh, sorry. I'm in Suite D, so I have my establishment name with my address on the front of the building.
Doesn't have its own entrance. You'd have to enter the whole suite and then come to your suite. Is that correct?
You are upstairs, I take it, since you included a picture of the staircase.
Yes, sir.
Do you foresee any issues with having an upstairs office and access for people with disabilities or?
And to come see them if they have any handicap issues, I would go to them.
Is there any requirement from the board on accessibility?
Well, the rule states that rule 666.022D states that if it's located within a business complex, whether establishment, there's a criteria, whether it's clearly separated from any other entity located within the complex and clearly distinguished by professional signage. So to the extent that if it's located in a complex with others, that it is separated from the others.
But no requirement on accessibility.
I'll be honest with you, I do not have a working knowledge about what the ADA requirements are for any actual business for accessibility. I do not. I do not know that the board has one on accessibility for persons of the public for handicap. I don't know of one.
Or is Mr. Harris's question about the Statement of Funeral Goods and Services. Mr. Glandorf and I have looked at the funeral rule, complying with the funeral rule on the FTC website. And the example that they give for the Statement of Funeral Goods and Services does not have a address on it, nor does it have a signature for the seller or purchaser. And all those, as it could be said, it's a best practice or a good practice to do it. The rule also says in the commentary part that it does not address the payment or the time of payment or things of that nature. So it's more of a disclosure, an informational document. More so, I think most funeral homes now treat that as a contract, but there's nothing in the rule that appears to require it to be treated as a contract. And I would ask if the board does approve the application that I know some of the documents that Mr. Kimmons has does not have Suite D on it, and I think there is a rule that talks about don't remember the exact wording of it, but not there'd be no deception or misrepresentation. So I think to the public that everything, if it is a suite, that needs to be included on the documents. to show that it's at 150 Uptown Square, Suite D, and not omit the suite, but include it. And that was probably just a typographical thing or a thing that failed to happen. But I do think it's important for the board to consider whether or not you want to require that.
Like to be done through an email, just for clarification, or
So we've got. I'm looking at the picture here. The signage on the outside, I'm assuming will be very clear. Now, what happens when a person walks on the inside? Is there signage on the inside that directs them to your office? And is is your office, like the door going in, clearly marked?
You'll have signage on that door. You walk in the suite, and then I have signage on my door, the Suite D. And I did all my paperwork is the templates from FTC.
How will you handle your merchandise selections in your office? Do you plan to do that digitally, or?
Yes, sir, digital.
Do you plan to offer stationery? I did not note any stationery offerings on your price list anywhere, or a price range of stationery packages on your GPL. Do you plan to offer stationery?
And I'm assuming, like you said, your wording is probably out of the FTC booklet, but I noticed that there's like use of facilities and staff for funeral ceremony at the funeral home. Well, there's not a funeral home there. You don't have a place to take it, so that probably should be other facility or whatever. But again, I know we're asking a lot of questions, and I certainly don't want to hold you to any higher standard than anybody else that's come through here.
Somebody correct me if I'm wrong. I think this has come up before. Does it not have to have its own separate entrance? Have we not come up with that before, or am I thinking of something else?
share a common door of entry, but then, isn't that right?
That was a problem. What Mr. Berry is referring to is a problem recently or within the past few months where that they had an office inside another business. In other words, they were proposing to have a funeral establishment inside the business of an unrelated business, and the board did not approve that. But there is a situation I'm aware of where that there's a similar to what Mr. Kimmon has in Murfreesboro, where that you go into an office complex and then the suite is separate and there's a direct entrance from the hallway into the suite, and there's no other business inside that suite other than the proposed business of the funeral establishment.
I think there's, if they're still there, there's long been one in Franklin, similar.
Brentwood, Frank.
Brentwood, yes.
Brentwood, yes.
The rule of the board allows that. That's a factor. So the rule is that you have a fixed business that is devoted to the care and preparation, and consider factors. You consider factors including but not limited to, and one of those factors is if it's located within a big business complex, whether the establishment is clearly separated from any other entity located within the complex and clearly distinguished by professional signage. So the rule is not an absolute must, cannot, but the board can consider the factors, all the factors involved of it in your decision.
I appreciate that. I'm just trying to make sure we stay fair and equal. Thank you.
And I think that one that was turned down just had a desk over in the corner of somebody else's office. I think that was basically what was going on there.
All of your areas in the photographs are exclusive to your suite. For example, the hall and break area, that is an exclusive area to your suite. It is not a public area that could be used or shared by other tenants in the building.
Now, their shared space is a sink and a hallway, but I have my own door. I have my own space.
What about offering pre-arrangements?
I don't plan on doing it at this time.
That indicated on the application? No.
I think it is.
Should be.
This is strictly a suggestion, Mr. Kimmons, but I notice on your casket price list, item number 9, you reference a solid bronze casket, but then in parentheses it says 16 gauge. Just to clear up confusion, you may want to address that as you move forward with your business. When I think about a solid bronze, I'm thinking about a 32 or 48 ounce bronze casket.
Color.
But you might want to say, as you did on number 8, a 16 gauge bronze colored steel rather than solid bronze. That could cause you some problems.
Just for my edification here, so that on the application, is it because there is not any pre-need sales agents listed that would make the assumption that there's not going to be any pre-need, or do we specifically ask that question?
There's a specific question on the application, and then when the inspector goes and does the inspection, I think it's at the bottom of page 1 on the inspection, then they make an attestation to the inspector whether or not they're going to offer pre-need.
That's on like the inspection checklist?
Yes, sir.
Okay.
And then if some establishments wait until they get their establishment license, funeral establishment license, before they apply for a pre-need seller registration. But of course, all of you are aware. But for those that might be listening later, if you offer a sale, then you're required to have a registration for a pre-need seller. No matter, in each physical location is required to have a separate pre-need seller registration. Sometimes that's confusing to people.
I'd make a motion to approve the application.
We have a motion from Mr. Berry to approve the application as presented. Do we have a second? Motion by Mr. Berry to approve. Do we have a second?
I'll second.
We have a second by Mr. Porch. Any other discussion? Any other questions for Mr. Kimmons or any other concerns that you wish to express at this time?
I think you probably got some issues with your paperwork to iron out and everything, and I trust that you'll take care of all that.
Yes, sir.
Okay.
There are no further questions. All in favor, say aye.
Aye.
Opposed? Motion carries. Congratulations, Mr. Kimmons. Thank you for appearing before the board today.
Mr. President, if you will, let the record reflect, I was still thinking through the blunt mortuary, but I was for that, and that was not voiced, so let that please reflect.
We have a unanimous vote then on the blunt mortuary application as well. All right. Gribble, would you want to speak to the public comment policy briefly that was sent out to the board? Is there anything that you note in that policy that needs to be touched upon with the board today?
I think we simply should talk about that the department encourages public comments and open meetings through various avenues and welcomes healthy debate and the expression of diverse opinions. And the department does have a public meeting comment policy, and that's available if someone wants to read the document in its entirety. But the general part is public comments and open meetings through various avenues, they're welcome. And obviously that document which was sent to you and you've read gives the chair the authority to limit, if there's time constraints, to limit the amount of time that someone speaks. And I don't know, Mr. Glandolf, whether or not the person, I guess it would be the chair, maybe the board's option, whether to allow them to speak without them actually being on the agenda or not. It's the only thing you have to be careful about is taking action. When speaking and commenting is totally different than taking action on an item. So just be aware of that. Also, Mr. President, last month when it was the last meeting, not last month, but the last meeting that Ms. Mendel and I were here, we were both participants in the Commissioners Academy. We talked to you about some conflicts that we had in meetings and things like that. Well, of course, since then, Ms. Mendel has gone to the other insurance division of the department, and I've checked my schedule, and the only conflict I have is in November. So we can talk about that when it gets closer. But I wanted to, of course, we have a normal meeting that's scheduled for next Tuesday that will be canceled and not take place. But then the next meeting would be the second Tuesday of September, and then the second Tuesday of October. And the formal hearing that was set for September, for the board's benefit, the consent order has been signed in that. Mr. Glandorf may want to speak about that, but there will not be a formal hearing. So at this time, there's no formal hearings that are set or pending any specific date or time.
That's correct. There was one that was pending, and that was resolved by a consent order that was signed by the respondent. Ms. Bendel had brought that matter to you all in her last meeting as a representation to you all with an authorization for settlement. That matter was settled. It was regarding a suspension of a license, which has a delayed suspension, and that has been agreed to. And we are just now finishing the filing of paperwork to get it officially off of the formal hearing docket with the Administrative Procedures Division. So that matter will not come before you all at a later date.
Remind everyone of the luncheon that will follow our meeting this morning, honoring our past board members, Mr. Bridges, Mr. Davis, and Mr. Duffer. That will take place at the Amerigo Italian Restaurant, 1920 West End Avenue here in Nashville. And we're due there at 12 o'clock. So if there's no further business, we'll entertain a motion to adjourn.
So moved.
Do we have a second?
Question before we do that.
Question, yes.
Our October meeting, can we look at possibly moving that in conjunction with NFDA? I know that's the third week. Could we possibly, or is that not a good idea?
I'm committed to speak on a panel at the NFDA on Tuesday of that week. Obviously, it's the board's decision, so I mean that's up to the board. But
question.
He's probably thinking everybody would be in town that day. Kill two birds with one stone.
Exactly.
But your obligation is probably going to conflict with the meeting
on Tuesday. I mean, that's obviously the board can meet on some other day. But
like that'd be a good thing for you as well as possibly for those that are attending. I don't know what other ramifications might be of changing the meeting
sometimes
day.
Meeting rooms are, and that's another question. Does the board have any? I mean, I guess we're going to watch the COVID numbers and things like that. But of course, obviously, we've been meeting over in 1B until the past few meetings we've been back and been in here, and we've been able to get this room. Does the board want us to continue to secure this room as long as we can for meeting dates until things change in the environment, so to speak?
I'm on borrowed time, but I think that would be a good.
I would think so.
I would think that would be a good thing.
Harris, to answer your question, maybe could I check on some information and follow back up with Mr. Shackelford, and then maybe because the board will meet again in September.
Yes, sir.
That'd be okay about the October meeting.
Very good.
I'll make a second.
All right, we have a second to adjourn. So all in favor say aye.
Aye.
We stand adjourned at 11:39.
Thanks for using WebEx. Visit our website,